I'm Ken Weinstein, President and CEO of Hudson Institute. I'd like to welcome you to the Betsy and Walter Stern Conference Center here at Hudson. I'd also like to welcome our viewers online, on Ustream, and at home on C-SPAN. And I also want to offer special thanks to the good folks at C-SPAN for carrying today's event live. We're honored to have Federal Trade Commissioner Maureen Ohlhausen with us today for what promises to be a fascinating discussion on what the federal government's role ought to be in addressing privacy concerns in the age of the internet. There are many interesting questions I'm sure that we're going to get to in her discussion with my colleague Harold Furchtgott-Roth in a moment. How far should federal regulators set the rules for privacy, and how much should we rely on the market to do this? How far can the market be trusted to protect sensitive information? And are regulators too rule-bound to be incapable of handling the often transformative character of technology that frequently leads to rapid changes in the way that information is handled? This should be an interesting discussion. Commissioner Ohlhausen, as her fellow commissioners know, has an independent mind on these issues, and we look forward to hearing from her shortly. Hudson Institute is a future-oriented international policy research organization founded by the late Herman Kahn. Last year, we celebrated our 50th anniversary. Herman Kahn, our founder, and his colleagues envisioned a think tank that would think creatively about what the future might look like and how to shape it, with the recognition that the world of tomorrow will be different in some significant ways from the world of today. Key to achieving a better future, Kahn argued, is the creative use of innovative technology, which can only occur in an encouraging policy environment. Today, Hudson continues this research in numerous fields, with initiatives on the future of innovation, forward-looking work on economics, healthcare, and philanthropy, to name just a few areas. Today's event is being held under the aegis of Hudson's Center for the Economics of the Internet, which is directed by Senior Fellow Harold Furchtgott-Roth. Harold, whom I have the pleasure to introduce, is simply put one of the most creative minds in Washington on telecommunications issues. An economist by training who did his undergraduate work at MIT and his PhD at Stanford, Harold served as chief economist of the House Commerce Committee and as a principal staff member responsible for the Telecommunications Act of 1996. He served with great distinction and unique insight as a member of the Federal Communications Commission from 1997 to 2001. Ladies and gentlemen, please give a warm welcome to my colleague Harold Furchtgott-Roth.
Thank you very much, and I very much like to welcome our C-SPAN audience and our online audience to this session of the Center for the Economics of the Internet. Before introducing our guest speaker today, I'd like to mention just a couple of housekeeping items. One, the Center for the Economics of the Internet would like to do its part to reduce unemployment in America. I'm very pleased to announce that we have a position open for a research assistant. Please contact the Human Resources Department here at the Hudson Institute if you're interested. Two upcoming events one is on November 28th. It will be advice for the next Federal Communications Commission. We'll be very fortunate to have two former chairmen of the FTC, Reed Hunt and Richard Wiley, who will come give advice after the election. On December 12th, Stephen Crocker, the chairman of the board of ICON, will come speak about issues before ICON, which is very sensitive to international issues related to the internet. But today, we're very fortunate to have with us Commissioner Ohlhausen of the Federal Trade Commission. The topic today is about getting it right. It's about who should be writing laws and regulating privacy on the internet. Commissioner Ohlhausen has a very long and distinguished CV. I'm not going to read it all for you. You can find it at her website at the Federal Trade Commission. I would like to simply say that Commissioner Ohlhausen has worked on privacy issues before the Federal Trade Commission since she was probably about 3 years old, I have to say. It has been the focus of her career. She is, I think, the foremost expert on privacy issues before the Federal Trade Commission. used, I think, combine both a clear understanding of the laws under which the Federal Communication operate, as well as a very heavy dose of common sense. It is my great pleasure to welcome Commissioner Maureen Olhausen here to the Center for the Economics of the Internet, and we're very much looking forward to your comments today.
You. Yes,
Please.
well, thank you so much for that kind introduction and for inviting me to address the Hudson Institute on the important role of the government's role in privacy and how to get it right. As you may know, prior to leaving private practice to join the Commission in April of this year, I had previously served at the Commission for almost 12 years, starting in 1997. My long experience at the Commission in the General Counsel's office, working for FTC Commissioner Orson Swindle, and as head of the Commission's Office of Policy Planning, has provided me an extensive background in all the areas in which the FTC operates, which is consumer protection, antitrust, and economics. And this experience really guides how I approach all issues at the Commission, including privacy. And so it's in this spirit that I would like to address privacy in the broader context of the FTC's current statutory authority to protect American consumers against deceptive and unfair practices, as well as the Commission's very important mission to preserve competition in the market. So I'm going to start with a discussion of our enforcement record based on our current statutory authority. And then I'll describe some other important functions and tools that we have at our disposal, such as our business and consumer education function and the critical role that that has played in the privacy area, especially in the online environment. And then finally, I'll highlight a little bit of how the Commission stays on top of emerging issues such as mobile technologies that are currently sweeping the globe. And then after my opening remarks, I'd like to spend some time really learning from you. One of the most valuable things that I can do as a commissioner is to listen. And when I hear directly from consumers and businesses and policymakers, my ability to do my job is greatly enhanced. So I'll pose several questions related to issues with which the agency is currently grappling. And I hope that you'll be willing to share with me your thoughts on these issues and how they impact you. And since turnabout is fair play, at the end, I'll certainly leave time for you to ask me questions. So I wanted to start with Section 5 of the FTC Act, which is the heart of the FTC's authority. And it prohibits unfair or deceptive acts or practices in or affecting commerce, and that's in the consumer protection area, and unfair methods of competition, which is in the antitrust area. And Section 5 provides a powerful law enforcement tool that has really proven its mettle over time as the mainstay of the FTC's enforcement efforts. And although elegantly simple in its text, Section 5 can reach a multitude of acts and behaviors and has really proven to be very flexible over the years. But a number of years ago, the Commission adopted separate statements on deception and unfairness to explain how we will use that to interpret Section 5 in the consumer protection area. There had been some questions whether we were using it too expansively, and so this was a way that the Commission really explained how it saw this very general grant of authority, how it would apply it and where the boundaries were for that. And those two statements continue to guide the agency's work today. And here's how they work. The deception statement explains that deceptive practices are representations, whether implicit or explicit, about material facts that are likely to mislead consumers acting reasonably. There's really a lot packed into that. And challenging deception has long been the core of the Commission's consumer protection mission, and it should remain so. And I particularly want to emphasize fraud. Privacy is an important topic, and we discuss it a lot. But really, the core of the Commission's consumer protection mission is challenging fraud, and it should remain so. Fraud is a serious problem that leads to monetary losses for consumers, as well as to a loss of trust in the marketplace. Excuse me. And this hurts both consumers who lose their money and legitimate businesses alike who may have to overcome some of the misimpressions that have been created or have to compete with companies who are making false promises that won't be adhered to. So in the areas of privacy and data security, the Commission most often uses its deception authority in cases where a company makes a representation to a consumer about the collection or the use of their personal information, but fails to keep that promise, and injury to the consumer results. And so deception is in contrast to our unfairness authority, which does not require a representation to consumers, but instead focuses on the consumer harm that an act or practice may cause. The Commission's unfairness statement requires that for the Commission to find an act or practice unfair, the harm it causes must be substantial, it must not be outweighed by any offsetting consumer or competitive benefits, and the consumer could not have reasonably avoided the harm. And the unfairness statement further specifically identifies financial, health, and safety harms as varieties of harm that the Commission should consider substantial. And it also states that emotional impact and more subjective types of harm are not intended to make an injury unfair. So to illustrate how the FTC's deception and unfairness authority works in the area of privacy, particularly online privacy, I'd like to highlight a very recent case. Just 2 weeks ago, we announced a settlement with Designerware, which is a software firm, and the 7 rent-to-own companies that deployed Designerware's software product in laptops they rented to consumers. So this is, consumers, they may not be able to afford a laptop and they go in and they rent it from a company. And so Designerware software had some legitimate features, such as a kill switch that the rent-to-own store could use to disable a computer if it was stolen or if the renter had failed to make payments on it. But Designerware's product also had a detective mode that was intended to help the rent-to-own operators track the location of the computers if they were stolen or if the payments were no longer being made on them. But the way detective mode was installed and the way it was operated by Designerware and the rent-to-own stores as well failed to provide users notice of certain features, which really raised a host of privacy issues. So when detective mode was activated, the software could log keystrokes, it could capture screenshots, and take photographs using the computer's webcam. And it also presented a fake software registration screen that tricked consumers into providing their personal contact information and was not used to register any software. And then data gathered by Designerware and provided to the rent-to-own stores using this detective mode revealed private and confidential details about computer users, such as their usernames and passwords for email accounts and for financial institution accounts, revealed their social security numbers, medical records, private emails to doctors and banks, credit card statements, webcam pictures of children in the home, and partially undressed individuals and intimate activities at home, as well as if they move the laptop around, the precise geolocation data. So the FTC's complaint against Designerware and the rent-to-own companies included both unfairness and deception counts. The deception count was very straightforward, and it was based on sending consumers the fake registration form to obtain their contact information. So clearly, this was an explicit representation about a material fact that was likely to mislead a consumer acting reasonably. So that's how it fits under our deception standard. But the Commission also charged that licensing and enabling detective mode, gathering this sensitive personal information about renters, and disclosing the information to the rent-to-own businesses was unfair. So specifically, the complaint alleged that the collection and disclosure of private and confidential financial and medical information about consumers caused or is likely to cause substantial injury to consumers. And I believe that this is consistent with the unfairness statement, which clearly identifies financial and health harms as substantial. The complaint also alleged that the defendant's intrusion into consumers' homes, the tracking of their locations over time, and the capture and disclosure of information, including images of undressed individuals and sexual activity, was also unfair. And the intrusion into the home and the sharing of such images, along with the tracking of precise consumer location over time, in my opinion, caused substantial injury to consumers by creating unwarranted safety risks that could arise from stalking or similar behavior triggered by such exposure and tracking. As for the other requirements for unfairness, which I mentioned is a 3-part test, because detective mode functioned secretly, consumers were never informed this was going to happen. They were never told when they rented the computer, oh, by the way, it has this capability and we might do this. That was never part of any kind of disclosure to the consumer. Consumers couldn't really reasonably avoid this harm. and any possible benefits of the practice, such as being able to find a missing computer, was really outweighed by its harms, particularly because the rent-to-own stores had effective alternative methods for finding and retrieving those computers. And I would note that as a general rule, I do not support holding third parties who simply create a product like software liable for actions that others take using that product. In this case, however, the determinative factor for me in not just holding the rent-to-own stores who directly interfaced with consumers, so not just holding them liable, but also the software designer liable, was that Designerware knowingly collected this sensitive medical and financial data and images from consumers, and also it generated the fake web registration form that it sent to consumers. And I think that rightly puts them on the hook, in my view. So why did I belabor this case? And it's not simply to highlight some distasteful computer snooping, but to emphasize that the Commission was able to stop this behavior under Section 5, and no additional authority was necessary. And the Commission's strong action in this case is not an exception. And so with our current statutory authority, the FTC has brought more than 100 spam and spyware cases and more than 30 data security cases, including against many prominent companies, as well as 19 Children's Online Privacy Protection Act cases. There have, however, been some calls for additional legislation. And in the FTC's privacy report, which was released shortly before I joined the Commission, some of my fellow commissioners called for a new privacy law that would go beyond Section 5, but they did not specify what such new legislation should look like. Also, the report did not identify what substantial harms are occurring now that Section 5 can't reach, although it did appear to embrace an expansion of the concept of harm to include reputational or other intangible privacy interests, which the FTC's unfairness statement indicated would not make an injury unfair. Obviously, in addition to the FTC report, there have been other calls for new, more general privacy laws from other quarters. And in thinking about these calls for additional legislation, I'd like to share with you a personal analogy, which I confess may have a bit of gender bias to it. But with the onset of our nice fall weather here in DC, I started thinking about transitioning my wardrobe to my fall clothes, to my cooler weather wardrobe. But I've learned before I hit the stores to buy anything new that I should really take an inventory of the clothes already in my closet to avoid buying things that I already have. And I believe it is similarly important for policymakers to take an inventory of what is already in stock in the FTC closet before seeking new privacy laws. And I'm not necessarily against new legislation, and there are a number of existing laws in addition to Section 5, such as COPPA, the Fair Credit Reporting Act, Gramm-Leach-Bliley, and others, that are an important part of the agency's enforcement arsenal. And obviously, there are privacy laws outside the FTC's purview, such as HIPAA. This audience, I'm sure, is familiar with the CP&I and the cable privacy laws that also provide important protections for consumers. But before seeking new privacy legislation, I think it's important to identify a gap in statutory authority or to identify a case of substantial consumer harm that we'd like to address but can't within our existing authority, especially given the array of financial, medical, health, and safety harms that are already reachable under our current FTC authority or other laws. Otherwise, I think it's very difficult to tell whether the additional protections are first necessary, and secondly, whether they will on balance make consumers better off. Because there are many benefits to information sharing for consumers, such as reducing online fraud, improving products and services, and increasing competition in the market overall. So that's why I'm concerned about treating privacy solely as a consumer protection issue. And I believe that privacy, like most other issues under FTC jurisdiction, must also be viewed through a competition lens if we want to reach the best outcome for consumers. And the FTC is uniquely positioned among federal agencies to balance consumer protection and competition in its analysis. For example, new privacy restrictions may have an effect on competition by favoring entrenched entities that already have consumer data over new entrants who need to obtain such information, or it could encourage industry consolidation for purposes of sharing data. And as a competition agency, the FTC should be sensitive to these kinds of concerns. So the Commission has consistently recognized the crucial role that truthful, non-misleading advertising plays in fostering competition between current participants in the market, as well as lowering entry barriers for new competitors. However, in its privacy report, the Commission did not address possible competitive effects of its recommendations, including potentially reducing the flow of information in the marketplace, and then certainly the services and products that depend on the accessibility and use of such data. And this could be an unintended consequence caused by compliance with new regulations, or perhaps an intended consequence depending on the type of data involved. So notably, the American Bar Association Antitrust Section filed a comment on the FTC's preliminary privacy report that highlighted the need to weigh carefully the benefits and costs associated with proposals to enhance privacy. And the ABA comment pointed out that although the report emphasized that to make meaningful choices, consumers need more information about how their data will be used, it did not assess the value consumers may reap from additional uses of their information that facilitate competition. For example, consumers who choose not to allow their information to be collected or shared may no longer be exposed to offers by competitors selling products or services that provide better value or pricing or quality. And in turn, these changes could have a negative consequence, not just for that individual consumers, but for the marketplace overall. And as the Supreme Court stated in the Virginia State Board of Pharmacy case, and I'm quoting here, advertising, however tasteless and excessive it sometimes may seem, is nonetheless dissemination of information as to who is producing and selling what product, for what reason, and at what price. So long as we preserve a predominantly free enterprise economy, the allocation of our resources in large measure will be made through numerous private economic decisions. It is a matter of public interest that those decisions, in the aggregate, be intelligent and well-informed. To this end, the free flow of commercial information is indispensable. And that's the end of the quote. So a policy that limits the ability of advertisers to access and use information to reach target audiences may have unintended effects on consumers and the marketplace that any policymaker, particularly one with the responsibility for consumer protection and competition, must consider. Now, of course, to raise this question of the effect on competition does not mean that I would never support any new privacy law. It simply means that I believe we must at least ask that question if we want to ensure the best outcome for consumers. So turning back to my earlier shopping analogy, there is one accessory that I would support adding to the FTC's fall wardrobe, and that's a uniform federal law for data security and breach notification. Although the FTC can proceed using its Section 5 authority, and since 2001 has brought over 30 cases against companies for failing to protect consumer information, I think there are gaps that could be closed through carefully crafted federal legislation. Currently, almost all states have data security laws on the books that require consumer notification if personal information has been compromised. And although some of the laws are similar, none of them are identical. And this means that companies need to comply with separate state notice requirements. There may be different triggers for notices based in different states, and consumers may get notifications that are different and reflect different types of data breaches. And I believe a single standard would let companies know what to do and consumers know what to expect. And I believe that if it's carefully crafted, such a law is likely to benefit both consumers and businesses, particularly because, unlike uses of consumer information for advertising or product improvement or fraud reduction, there are no benefits to consumers or to competition from allowing consumer data to be stolen. Of course, any such law would have to be carefully crafted to decide what are reasonable precautions for safeguarding various types of data to avoid imposing undue costs that are not justified by consumer benefits. So I've talked a lot about law enforcement here, but I also wanted to talk a little bit about some of the other tools that we use at the FTC. And so while law enforcement is critically important, in some respects, the Commission's consumer and business education mission impacts a greater percentage of American consumers than anything else that we do. For example, the information available on our webpage to help consumers avoid becoming victims of identity theft has had millions of hits, and the paper versions of these have had a very wide distribution to millions more consumers. And if prevention doesn't work, we offer excellent resources on steps to take to mitigate the damages of having your identity stolen. And we educate consumers on how to establish and protect their credit scores, how not to fall victim to scams, and about the ever-popular Do Not Call list and how to sign up for that. In addition to the consumer education, the FTC produces, in addition to this kind of like protecting your identity information, we also produce consumer education about keeping kids safe online, such as our award-winning brochure for parents called NetCetera, Chatting with Kids About Being Online, and a community outreach toolkit that helps other people like community organizations, scouting organizations, churches, other civic organizations share this information with people. And this type of outreach is an area of particular strength for the Commission. We also sponsor public workshops on a host of consumer issues. And these events help our staff understand complex issues from a variety of stakeholder perspectives and also provide us a forum with which to share our agency expertise. On this Thursday, we're holding a public workshop on robocalls to explore innovations designed to trace robocalls, prevent wrongdoers from faking caller ID, and to stop unwanted calls. And panels will discuss developing solutions to the problem of unwanted robocalls and call authentication and call blocking. So that's kind of how we approach things often. If there's a new issue, a problem issue, we'll have a workshop before we take any positions and find out from the industry, what problems they see, solutions they might have. We hear from consumer groups, we'll hear from academics, we'll often hear from technologists, and just really try to get a very clear understanding of what the problem is. And just yesterday, the Commission announced a workshop to be held on December 6th, which is to explore the practices and privacy implications of comprehensive collection of Internet user data. So this is another privacy-oriented workshop. And this workshop, like all the others sponsored by the FTC, will include speakers representing all the major stakeholders in the debate. And details about this workshop are available on our website, ftc.gov. So finally, one of the biggest challenges faced by the FTC and really any government agency is keeping abreast of new technologies and understanding how they impact consumers and privacy. And mobile technology is really a great example of this. And while smartphones have only been available for a few years, everyone knows the market penetration has been phenomenal. By February 2012, over 88% of Americans owned a mobile device. And mobile devices offer consumers, many, many benefits, such as new services and convenience, but they also raise unique privacy concerns. And these privacy concerns arise from the ability to provide real-time location data, the small display screen for disclosures, in the laptop era, in the desktop era, disclosures could be displayed on a much bigger screen, but now that it's shrunk down, can consumers see the privacy disclosure, or there are some ways that could be done better? And also the wide variety of uses of our smartphones, from being a payment device to possibly being a medical device. So all of these raise privacy issues. And so because mobile technologies are moving with lightning speed, the Commission determined it needed to have a dedicated staff working exclusively on mobile issues, and thus the Mobile Technology Unit was established. And this Mobile Technology Unit issued a report on mobile apps for children and hosted a workshop on mobile disclosures, including privacy disclosures. And the report and the workshop examine the adequacy of information that app stores and developers provide to parents about what information is being collected, how it will be shared, and who will have access to it. And we also have reached out to industry to work on improving these disclosures. And this unit is now following up with a survey to find out. Now, we looked at apps and we looked at the privacy disclosures, but we needed to look at the next piece, which is what apps were actually collecting information, what types of information they were collecting. So that's the next piece. And this mobile unit has also brought 6 law enforcement cases. So I've covered a lot of ground with you today. And so just let me briefly restate the 3 points with which I hope to leave you. First, I'm not convinced that the FTC is currently lacking any statutory authority in the general privacy area. And for now, Section 5 seems sufficient to protect consumers. Second, the Commission must analyze issues under its purview from a perspective that covers both consumer protection and competition, or it may not reach the best result for consumers. And finally, the Commission should use all the tools in its arsenal, so law enforcement, business and consumer education, research and policy development, to reach sort of the maximum target audience and also to find out, what issues do we need to know about? What should the Commission be focusing on in the future? So as the newest commissioner at the FTC, but in some ways the one with the most experience at the FTC, I pledge to do what I can to ensure that we do all in our power to further the interests of American consumers. So that kind of concludes my remarks, but I wanted to hear from, we seem to have a very knowledgeable audience here, and so I'd love to hear, from the audience and from others about some of the issues I'm considering. So should I join you here at the table?
However you want to do it.
Thank you.
Thank you very much.
Oh, you're very welcome.
For those very thoughtful comments. We've been very much expecting to hear these thoughts on privacy. And for the folks following us online or on C-SPAN, you can submit comments either on Twitter at #HudsonPrivacy or on Facebook at facebook.com/Hudson Institute. With that, let me return the podium to you, Commissioner Olhausen, to ask the questions of the audience.
Great. So do you think the FTC has done enough to inform industry about the agency's expectations when it comes to privacy and reasonable data security measures? And if not, what else should we do? Do folks feel like they're in the dark? Do they feel like they understand, what we expect and why we expect it?
Please identify yourself and
Henry Hetker, researcher at NARA. Somewhere along the line, maybe within the last 5 years, the Supreme Court made a ruling on internet sales, which, more or less has something to do with FTC because a lot of the internet sales were false. In many cases, the buyers were taken. And I've been one of them. I've suffered a bit, like many other Americans. And we wondered about how to recover anything. And all eBay could tell us was you'll have to go to court and go to the state where this company is and try to sue them in court, go in and present a case. So that's basically where we were. And it made it a very difficult decision on what to do about things. And I just wondered, that being the case, the Supreme Court, people went all the way to the Supreme Court on some of these issues. And the Supreme Court seemed to indicate you've got to know your seller to some extent. You've got to deal with them on a personal level. You have to either speak to them on the telephone or somehow know them directly. You just can't rely on the internet where there is no close interaction between buyer and seller. And this has really set things back for internet purchasers. You're at great risk in doing this. The eBay company did set up PayPal, and then on top of that, eBay buyer protection, but it has like a cash limit. So you're still at risk on higher priced items. I wondered, is there any more review of this type of case, and what can be done to strengthen internet sales, since you yourself are interested in the internet?
So you raise a good point about internet fraud, and that is certainly a problem that the FTC has been trying to address, I think, since the advent of the consumer internet. And we have tried to be active in a lot of those spaces. It's an issue certainly for consumers if there's deception, if they've been told, the product is one thing and they get something different. That's certainly a problem. And we've brought sweeps of cases. We also try to engage in consumer education to warn consumers about what scams might be going on. We also have international, like we have the U.S. Safe Web Act, which allows us to share information internationally to find out if there's any internet scams being directed into the U.S. from call centers outside the U.S. So it certainly is you raise a good point. It really is a problem, and we are trying to address that.
Thank you, Commissioner, for your comments. this summer, the Aspen Institute, Aspen Summit that TPI had, there was a discussion about innovation and the FTC's role and how innovation happens. One of the questions was there were two commissioners at that point on the panel, was how companies know if the innovations they're talking about may go across a line that the FTC may get concerned about. Some of the comments were that we probably should try to come up with a bright line. Other people said if you do that, you may actually harm innovation. And I guess I wonder about that issue because it is an important one for companies to understand, you know, what the FTC looks at in this space. And I give you one specific example. In the privacy report, there's this workshop you referred to. And my view of workshops is generally they're designed to educate the FTC ahead of time as to what issues that they need to look at and then maybe do something about. This workshop was proposed after the FTC did the privacy report, and it seems to me it's kind of backwards. And I'm not really sure what this workshop is going to be, what the purpose of it will be. So maybe you could comment on that, because I think that whole workshop is going to have an impact on, could have an impact on innovation.
So you raised two issues there, and I'll try to address both of them. And the first one, the FTC tries to look at everything from the consumer's point of view. So certainly in the area, if there's a promise that's been made to a consumer about how his or her information will be used, the consumer expects that promise will be met. Beyond that, where there's not a promise and we get into unfairness, it should be something where if there's a harm, financial, medical, safety, and children are a special case under the Children's Online Privacy Protection. So those would sort of be our starting points for where the line should be. But obviously the lines can blur a little bit, and they can change over time because consumer expectations can change, and consumers have more knowledge over time about certain uses. But then something new comes along, and kind of everyone has to adjust to that. And now, as for the workshop that's coming up, I think one of the things it's aimed at is a lot of our previous work has looked at online behavioral advertising. A lot of the discussion has been in the context of online behavioral advertising. And I think the Commission would like to broaden out to look a little bit more into other ways the data is being collected, not just through online behavioral advertising or uses for online behavioral advertising. So it's trying to look, I think, at a broader pool. The fact that we're looking at it doesn't necessarily mean that we will do anything additional, but it's a good way to keep ourselves up to date on sort of what the developments are.
Hi, this is Juliana Grimal with National Journal. I just want to ask you if you have any thoughts on what came out of Europe today as far as some of the changes that the European data privacy commissioners called on Google to make to its privacy changes. I mean, the FTC did not do anything in response to that, but do you have any thoughts on some of the recommendations the Europeans made to Google on that?
So I only got to look at them very briefly, so I wouldn't claim to have deep knowledge of them. But some of the things that they are emphasizing are, fuller explanations to consumers of what the data is collected and how it will be used, particular concerns about mobile, and sort of having these deeper and more advanced privacy notices, which I think is interesting, and certainly the European model is somewhat different from the U.S. model. So one of the things that we talked about, or the FTC talked about in the privacy report issued before I came, is the concept, though, of giving consumers maybe layered notices or notices in a way. Not every consumer wants, the most detailed explanation, but maybe it should be there somewhere for the consumers who are the most privacy sensitive and the most interested. So I think there's this tension between giving consumers tons and tons of highly detailed information and really overwhelming them with an amount of information that most consumers wouldn't find useful. So we're trying to find the right balance between providing kind of the top level, the top line information that many consumers would like versus very, very in-depth. And I think in the EU, they may come to a different balance than we would in the US.
Commissioner Olhausen, Baron Soka from Tech Freedom. So getting back to your question about, or the question that was discussed earlier about how the FTC can adequately inform industry of what the rules are and how to predict the FTC's actions in the future. In most areas of the law, of course, counsel for companies, especially small companies, can look at case law and understand how decisions were made and can offer their clients guidance to tell them how they think concepts like deception or unfairness will be applied in the future. And that's also true on the other side of the aisle for your agency in antitrust, because there are actually court cases that decide these things, and those are then summarized by the agency in the form of guidelines. The problem that I see on the FTC side for consumer protection is that doesn't happen. That process is short-circuited because until the Wyndham case, I'm not aware of any company ever having actually litigated a privacy case. So in light of that, how do you think that the FTC can, if we take that for granted, actually try to solve that problem to provide more guidance to companies about not just what particular practices that they find illegal in a particular case, which of course you could see from a consent decree, but more importantly, what their analysis is in those cases, how they think they have satisfied the unfairness and the deception policy statements. So what do you think about that, and would you support in particular having the agency, instead of issuing reports that offer its views as to what the law should be or as to what best practices should be, maybe actually issuing guidelines that explain how the agency has in past cases applied those doctrines in order to give some understanding in the future as to how the law might develop, and then going forward in every particular case doing more than perhaps the normal federal rules of pleading would require when they bring a case, explaining more, knowing that the case is not likely to actually be resolved in court, knowing that it's going to wind up in a consent decree, and that the initial pleading and the consent decree are really all that anybody on the outside has to look at in understanding how the agency interprets its own longstanding policy statements.
Well, I'm a big fan of agency transparency overall, and this is an issue I've talked about on the consumer protection side and the antitrust side. And I think it's incumbent on us to give clear guidance to all constituencies, businesses, consumer groups, Congress, anybody who's interested, really, and what the FTC sees as its mission and how it's applying its laws in a particular instance. So I do think it could be useful to have something like guidance or further guidelines on where we see things in the privacy area, where deception is, what's unfair. And I do think one of the benefits of actually having a litigated case like Wyndham will be to test whether we're right. Does the court agree? Have we drawn the lines in the right place? And I think that is one of the benefits. Now we do have, when we have a consent, an analysis to aid public comment that gives some discussion, and maybe our discussion could be full. And that's something I would definitely consider. And I think on the antitrust side, I recently objected to the FTC rescinding some policy guidance about how it would be applying some of its enforcement tools.
Yes, ma'am. I just wondered where you were on the Google antitrust investigation, if you supported that or what you thought the issues were.
It wouldn't be appropriate for me or really any other agency official to talk about an ongoing investigation, so I'll have to decline.
Does the national do not call list, do they exempt political campaign advertising?
They do not, and the reason is because it's not a commercial call. It is has a different level of protection under the First Amendment. So there's a doctrine between the commercial speech doctrine, where commercial speech can be subject to more regulation than political speech could be. Did you say accept or exempt? I'm sorry, exempt. It does exempt it, yes. Because under the First Amendment, political speech has a higher level of protection than commercial speech. So we can't regulate it in the same way. Should I ask another question? Or
Why don't we ask another
one?
question?
Okay.
I'm sorry.
Okay.
There is another question.
There is another.
Madam Commissioner, I thought your presentation on how privacy policy fits into Section 5 was very persuasive. However, it seems to me that there are a substantial number of cases where Internet firms are collecting information on consumer behavior, not for the purpose of improving service to that customer, the way Amazon tailors new book announcements depending on what you've purchased in the past, but simply gathering aggregate information that may have some public good, but really doesn't affect me as a consumer. I'm not sure how Section 5 quite fits this very substantial amount of collection of information about the behavior of individuals for purposes of putting together large aggregates. If I'm told by some firm that I'm doing business with on the internet that they want permission to collect information to improve their services to me, I can imagine one answer. And if they just want to collect it as part of some general customer behavior information that's going to have no effect on me, I might give them a different answer. So if you had the same amount of preliminary disclosure, I'm not sure that that really fits, because a lot of this information could be very valuable. The privacy implications to the individual could be trivial to non-existent, and yet if you had you had disclosure and so forth and so on, you could get very low. It could impair the value of the information that they collect.
Right. So there are many different types of information that could be collected of varying levels of sensitivity. So, for example, a company, an ad network might be interested in collecting, ideas of like what people, if you go to a sports site, what website are you likely to go to next? Are you likely to go to another sports site, or are you going to go to a news site, or if you're at a golf site, or you're likely. So there's all different levels and ways that information could be used. There's a lot of options being considered now to give consumers a little more nuanced control about some of the collection and use of their information through online behavioral advertising or online tracking. So in the FTC's privacy report, they tried to capture some of this, focused on the context of the transaction. So because the other thing is you don't want to flood consumers with too many, check this box, or here's what we're doing, because that becomes just an impediment to them. So we try to look at the context of the transaction, and does a consumer expect that this information will be used in a certain way? Certainly one of the areas of wide discussion right now has to do with online tracking, and perhaps the ability to give consumers a little more of a nuanced choice, which is something, I know I'm interested in seeing how the self-regulatory process plays out, to see if something can be reached that would give consumers who are interested that level of control to opt out some of the information.
Hi, I just had another question. Do you know when we'll see the revised COPPA rules? And also, do you support sort of the latest proposed changes?
So because it is an ongoing rulemaking, I can't really comment about the COPPA rules. It's before me for consideration right now, much like an investigation. So, sorry. The comment period closed on September 24th, I believe. And we got a lot of comments, so we're certainly reading through them and going through all of them, but I don't have a prediction about exactly when a decision might be.
If I could just make a point on process, Commissioner Olhausen has very cleverly come up with a new format where she asks questions and the audience is supposed to respond. Yeah. And we will have a session for general questions afterwards. So I think the question before the floor is, are there better ways that the FTC can give information to the public about certain issues, and I think to the extent we're going outside of that, then let's get back to Commissioner Olhausen's questions.
On privacy, it's related, I think, but basically, I just wondered if the Commissioner thought there should be more cooperation between the U.S. and Europe on privacy regulation, and if so, what you could do about that.
There are ongoing dialogues between the U.S. and Europe on privacy. I think that's an important role to help international commerce. So my understanding is that there's a lot of it going on now. I don't know whether we need more or not, but I can say that there is a substantial amount occurring now. And I can broaden out my question, actually, beyond, to ask generally, what do you think we should be paying attention to in the future? What do you think is coming down the road? Is it cloud computing? Do you think that will raise issues we should pay attention to, or mobile payments? Some of the new services and things available to consumers these days. Stunned everyone in his.
Well, I'll follow up on that. Okay. And this actually does go to some of the international issues that are particularly created with cloud computing, and just the jurisdiction of servers around the world. A user may make an inquiry online, and it might pass through countless numbers of jurisdictions. Which privacy laws apply, both from the perspective of the consumer and also from the perspective of information providers along the way?
No, I think that raises a very important issue. It's something that cloud computing, as you say, cloud computing. And the FTC has been trying to make sure that consumers' expectations in the U.S. and promises that are made to consumers in the U.S. are fulfilled. We do have the Safe Web Act, which is a way for us to be able to share information internationally and gather information. It is up for renewal by Congress, and we would hope we would get it renewed. It expires next year. But that is a challenge, and because countries have sensitivities about people coming in and getting information, from servers located in their country. I wish there was an easy answer, but I would say if a company in the U.S. makes a promise to consumer that information will be protected in some way and that it's violated, even if it's because of a breach that occurred, somewhere else, though if it was under the company's control, I think we could probably still establish, FTC jurisdiction.
I was going to say third-party tracking, notifying consumers notifying consumers of third-party tracking. You don't know who's tracking you and where it's going. You click on a link, you want to buy something, and at the bottom of your bar you see all of these click sites popping up that they're paying your primary site to access what you're doing. So more disclosure of third-party tracking and protections from third-party tracking that people don't know about.
It's good for consumers to know.
Well, building on my earlier question, it seems, I think, implicit in the FTC's mission that unfairness is about weighing substantial injury against countervailing benefit, as well as the degree to which consumers can themselves avoid a practice that is concerned about. I think it'd be incredibly helpful for the FTC to do more quantitative work on exactly what the substantial injury is we're concerned about. In other words, how doctrinally does the FTC define harm? What sort of benefits do they see? How do they weigh those things against each other? And what sort of user empowerment tools are out there, and how do we know if they're good enough? I think those three questions would be incredibly helpful, and they're not new questions. They're questions that are already inherent in your policy statement. And the Bureau of Economics is a great resource, and yet I've seen nothing from the agency on that to try to quantify any of this or provide some analytical rigor that could both inform policymakers and also help us understand what the agency is doing, and maybe put to bed some of the myth that the agency is helpless without new legislation, which might be particularly helpful in Europe, where everyone seems to assume that we don't have a baseline consumer protection law, which of course we do.
Well, I think your points really do echo what I said in my remark, that we should be asking these questions. And one of the things we should also consider we are an agency with limited resources, so we need to focus our activities on areas where the most consumer harm is happening. And if there are tools in the marketplace, there are options in the marketplace that consumers can use to better express their privacy preferences, that's an important thing to think about. We want to focus on problems that consumers can't can't necessarily fix themselves.
I was wondering to what extent you might be involved in mortgage financing problems or issues.
Right. So the FTC, we do have a division of financial practices, and certainly deception and unfairness applies, not just to privacy, it applies across the board to all of our work. We share jurisdiction with the Consumer Financial Protection Bureau, but we can bring enforcement regarding non-bank lenders. We don't have any authority over banks. We never have. So that's something that we pay attention to. Our Division of Financial Practices has brought a number of cases involving failure, deceptive practices in mortgages. Again, but it has to be from a non.
Not germane to the overall topic, but to follow on to the past question. So there is this new kid on the block, the CFPB, and you got to sort of, two bureaucracies got to sort of find out where one begins and the other ends. Do you have any thing to tell us about what the experience has been to date of finding out where those lines are?
Sure. So we have a memorandum of understanding with the CFPB, and we are trying to make sure that we're not imposing things that are conflicting or that are duplicative. I think it makes sense for us to continue to focus on non-bank lenders and for them to be active in areas that we can't be active in. We actually have a number of other agencies that we share jurisdiction with. The FCC was one of them, certainly Department of Justice, Antitrust Division, FDA. So we've had a history in the past of being able to share things fairly efficiently with other agencies. I hope we could do the same with the CFPB.
Commissioner, following up on that, there must be cases that potentially involve one or more agencies, and how does the FTC go about resolving jurisdictional conflicts?
So we have a very good staff and a very active staff, and they have a lot of interaction with the staff of other agencies. So, for example, there's the Identity Theft Task Force. There's a number of different agencies that play a role in that. So we would, try to address issues through a task force like that. On some areas, I have the most experience with dividing things up with the Department of Justice Antitrust Division, certainly, where we have basically an informal clearance agreement based on expertise. And then there were some carve-outs that we have. But for example, in my previous incarnation at the FTC, we brought a lot of cases involving real estate and issues involving online real estate, kind of new business models that traditional realtors were setting up rules to sort of fence off competition from those. And so we in the Department of Justice did that together, where the Department of Justice brought the case against the National Association of Realtors, and the FTC brought the cases against local monopolists. So there's a variety of different ways that we can do it, where there's overlapping jurisdiction. Sometimes it takes a little more cooperation. But for example, in certain areas like the FTC has a common carrier exemption. And so a common carrier acting as a common carrier, we can't bring a proceeding. But for some things involving like cramming of false charges onto a bill, we can talk with the FCC, who might be able to focus more on the carrier, and the FTC, who could focus on the third-party aggregator.
Next question.
Okay. So let's see. I guess one of the things, and it's been touched on a little bit, involve the Do Not Track initiative, the self-regulatory attempts to give consumers this additional level of choice, including the deliberations that have been happening before the W3C. And I would be interested in hearing knowledgeable folks' views on how you think that process is going and what you think the outcome will finally be. Will they reach a resolution or have things stall?
I hate to seize the microphone here, but I think I'm the only person in the room that's actually involved in that process as an invited expert, and I have to say that it's not going well. It's really remarkable to me that this process, which I think many people in industry in this country signed onto on the understanding that they reached with the White House in February, that this was really intended to work out a technical specification for implementing the Digital Advertising Alliance's commitment to build a user-friendly opt-out tool, have been very, very surprised that the process has turned into a policy-making process that really is intended to reshape how data is collected worldwide. And in particular, I think they have felt, and I've seen firsthand, that there's been strong pressure brought to bear through that process, through a combination of Europeans on the one hand, in particular the Article 29 Working Party, of European data protection authorities, the FTC itself, whether they intended to or not, but by participating in this process, they have sent a message to people in industry that they had very well better comply. And some of your fellow commissioners have made comments to the effect that non-compliance with an industry standard could itself be actionable under Section 5, which I think has really intimidated many in industry. And then finally, it must be said that this is, at the end of the day, a process by which major players, in particular the browser makers, are frankly colluding to change the way that the internet works. And that may be for good ends, but it's a process that normally would raise antitrust scrutiny at your agency rather than being encouraged by your chairman. So it has left many of us scratching our heads as to why it is that this international body, which includes no democratically elected people, it has no official role in any of this, is trying to reorganize data collection in the way that really could fundamentally change the way the internet works, that could privilege some business models over others, and could allow some companies potentially to gain a significant leg up on their rivals by, I think, frankly, cynically invoking the concept of privacy. So I have to say, for all of those reasons, as well as the fact that that entire procedure is operating on the basis of undefined terms, that is to say, about 20 of the key terms that we're talking about are still not defined, it's really not possible to reach any sort of consensus on those things. And then just two quick final points. One, the process is supposed to resolve matters based on consensus, and I think there's a strong feeling in the room that that's not actually being followed, that the chairs and those who are making decisions are doing so because they have preconceived notions about what data collection should look like. And then finally, the entire process, I think, is being rushed through on a political schedule, which is, one, in the U.S., I think it's pretty clear that your chairman has put a lot of time and effort into this and would very much like to see it resolved. I don't think that's a particularly good reason to rush the process forward. And on the other hand, in Europe, of course, the Europeans have made it very clear, most recently Nelly Kroes, that their regulation is going forward early next year, and they'll go forward with or without the W3C. And at the end of the day, all this is just to say that enormous pressure is being brought to bear on everyone in that process, and yet we're a very long way away from reaching any sort of real consensus, and the very process itself is subject, I think, to some important criticisms that are really not going heeded here, because much of the coverage about this has really focused on this as being a noble effort that is intended to protect consumers without any real awareness of what's really at play here, the other forces at work, and indeed the limitations of the process as it is. It isn't and it never was a limitation on tracking. It is a limitation on use. And I think now that people are finally starting to understand that here, it's starting to cause some folks in Congress to get upset about this, and that in turn is helping to, I think, derail that process. So in answer to your question, I'm not very optimistic, and I'm more than a little concerned about what's been driving it.
Well, it's good to hear views from lots of different people. You raise a couple of important points. I believe on the issue of whether it would be actionable under Section 5 for a company not to adhere to the standard, if a standard results. I believe that would be based on if a company says it will adhere to it and then it doesn't. That was kind of a traditional FTC type of case, and maybe not so much that if there's a standard out there, you must adhere to it even if you haven't promised. Then secondly, in any standard setting organization, there are certainly competitive issues that can arise, and that's the kind of balance. There are many pro-competitive self-regulatory organizations and activities and standards, but not to discount the possibility that in some cases something anti-competitive could arise. But I appreciate you, kind of raising those concerns, because that's the kind of thing that, is very helpful to me to hear about, is to hear what people are thinking about this process, to see whether, we'll ultimately offer a new option to consumers or whether they won't be able to reach a consensus.
You want to try another question?
Oh, let's see. So some folks have touched on this already, but I wanted to put it out sort of more overtly. So given the dynamic nature of high-tech markets, where do you see the biggest pitfalls for the FTC's enforcement efforts in both consumer protection and competition matters? Where do you think, our efforts could raise the most risks of not having a beneficial outcome for consumers? I'm sure it's not the case that everyone thinks that everything we do is wonderful. So maybe discretion is the better part of valor.
I'll raise the
Okay.
issue. This would be more on the antitrust side, and the challenges of defining markets in high technology areas where technology is rapidly changing, and it's really very difficult at times to figure out, well, how do you define the market? Who are the market participants? And those might change 6 months from now. And it strikes me as very interesting, actually, that if you look at some of the largest technology companies in the United States, the antitrust issues have been more of enforcement of unfair competition issues than they have been in, say, the merger and acquisition context. I was just curious if you have any thoughts about how the FTC looks at defining markets in high technology areas.
So you're absolutely right. Those are markets that are, marked by big changes. The new competitor comes and everything looks different. And one of the things we need to be aware of and careful about is that we are trying to make our enforcement decisions and our predictions based on the world as it is right now, or maybe where it will be going in a few months and not where it was a year ago. So one of the tools that we have, Barron touched on this a little bit, but I wanted to highlight it, is we do have an entire Bureau of Economics. So we have economists who can help us try to figure out these things. And it's one of the things we've been able to use in the past to figure out, are we taking the right factors into consideration, is to do a retrospective and to say, we made this guess that the market would be a certain way. Were we right? Did we come to the right conclusions? Did the bad things that we think would happen, or did bad things happen that we didn't foresee? And so one of the things that often comes to mind, now this was a transaction that ended up being abandoned by the parties, but it was, I believe in 2005, Blockbuster and Hollywood Video wanted to merge. And the FTC was reviewing it. And again, they
Right.
abandoned the transaction, but I'm not sure at the time we really understood how quickly streaming was really going to start to take over that market, and how much, between Netflix with discs in the mail and now everybody, being able to access video content through a lot more channels, what that really meant for that. And sometimes things change during our review of a transaction. So, for example, the Google AdMob merger was an issue where when we started investigating it, there only just seemed to be a certain number of players in the market, and then another strong player said that it was going to enter, and we ended up closing the investigation and explaining why. So it's something we need to pay close attention to. I certainly think that using, our economists, also our function of getting out and talking to a bunch of different groups and trying to stay educated a little bit ahead of things. When I used to be head of policy planning at the FTC, that was a job that had no inbox, right? I wasn't getting merger filings. I wasn't getting, you must solve this in a certain amount of time. My job was to try to see over the horizon a little bit and see what issues the FTC really needed to educate itself about in time to really understand the changes in the market. So it's something that we need to keep as an institutional function to keep in mind. So we need the resources and tools in the agency to be able to do that.
Questions from the floor?
Yes. Thank you, Commissioner. Ken Dante, just the question, if you were to project into the future about 20 or 30 years, and I know this is a grand crystal ball type of thing, but that's part of your job in a way too, I would think. Given some of the inroads in privacy and security, and also the inroads of the marketplace into people's privacy, what kind of world are we constructing? It almost strikes me a little bit like 1984 on one level, but Brave New World on the other, where people find those things that will please people, and you're sort of pleasing the consumer, pleasing the masses. What do you predict our world will be like? What will our psychology be like? You know, because we're affected by either how exposed we are or how our sense of security is affected by that.
So one thing I would mention is I realize that I'm not good at predicting. Okay, my sister is a computer science PhD, and she was in this field way before I really knew what any of this was. And she told me a long time ago, there's this thing called the internet that we computer researchers use we put up our CVs, they're called pages, and we see what research others are doing so we can collaborate better. And what I said to her was, oh, how interesting. And what I thought to myself was, doesn't sound very useful to me. So I understand the limits of my ability to forecast in that way. And so one of the rules that I try to apply is to not try to come up with a solution to, now for something way in the future. So that's one thing, because I think our ability to know what the problem is and what the problem will be a year from now doesn't mean we shouldn't look at it, but we should be careful about imposing solutions that are too restrictive and don't take into account these changes that might occur. The other thing that I wanted to mention is that there is a big difference between how young people view their information and their privacy and how older people view it. And so I think a number of years ago it would have been hard to predict that people would share their information so freely, that people would feel so comfortable with it. But what we're supposed to be doing at the FTC is reflecting consumer preferences and not replacing consumers' preferences with our own. So that's another thing that I want to keep sensitive to in the future, that this is something that, if consumers feel comfortable doing, as long as, there's not something happening they don't know about, then my job is to help to make sure the promises that are made to consumers are kept, and that consumers get to have an array of choices in the marketplace to meet their own preferences.
Hi, Matt Starr, Tech Freedom. You had mentioned earlier that the FTC has limited resources. What are your thoughts on developing more in-house expertise, such as the Bureau of Economics?
Yeah, so we have about 70 PhD economists on our staff, and we try to have them certainly do case support, but also to be able to do their own research so that they can develop expertise in some areas that may not be useful like right now, today, on this particular case, but might be useful in a year or two. We also now have a chief technologist on staff, which I think was a very good development. And the other thing that I encourage, we had a budget meeting earlier this year, and one of the things that I encouraged the agency to consider is the federal workforce is going to face a lot of retirements in the next year or so, and that we should consider as those people retire, that the young people we bring in, or I shouldn't just say young people, but the non-retirement age people that we bring in have some of these skills, have some of this knowledge and familiarity with new technologies, new uses of technologies, and things like that. So there's a way for us to keep abreast of changes by kind of updating our workforce naturally as people retire and they get.
We have an online question from username Howard Feinberg. If the NTIA multi-stakeholder process on mobile apps privacy does not agree perfectly on a voluntary code of conduct, will the FTC just enforce their own? I don't know.
Well, so our code of conduct, our baseline is always going to be deception and unfairness. So if there's a promise made to a consumer that's not, then that would be a problem. And if information is sensitive information is collected and its use would meet the unfairness doctrine, then we could proceed, certainly. I think the FCC may have a role to play in this as well. That's something we. There is a baseline, even if there is something additional.
You mentioned the notion of consumer preferences and wanting to reflect consumer preferences. There are a lot of people out there sort of representing consumers think this, that. How do you sort of acquire knowledge in this domain? What do you know? What would you like to know?
So I would love to see some more research on these topics. What do consumers really think? What kind of choices would they make? I mean, it's very easy in response to a survey to say, oh, I wouldn't like this or I wouldn't like that. But how do the consumers really behave in the real world? I would find that useful. There's some economic research that has been helpful that also looked at, there's always going to be advertising. The internet is generally an advertising supported model. So if we restrict some kinds of information collection and use for advertising purposes, that doesn't mean advertising is going to go away. It means you're going to get a different type of advertising. And is that better for consumers? Do consumers prefer that versus the type of advertising that they may get when some information about them is collected and used? So really kind of a better understanding of the economics of information exchange and the kind of the but-for world would really be useful to me.
A follow-up, in a lot of areas I've observed, especially about economic behaviors, more information coming not from surveys but from experiments.
Mm-hmm.
So is the FTC in a position to fund any experiments, or you're going to have to rely on the helpful efforts of others?
It's possible we may be able to do some economic research in this area. We certainly do have some budget for economists to do that. But one of the things that I found when I was head of the Office of Policy Planning that really paid dividends is when we were able to focus attention on an issue and academic researchers took it and ran with it. Often academic researchers are looking for a topic that they can do something new in, but that will play into a larger debate, so it gets a little more exposure. So I think that being able to get out and talk about these things, I hope would seed some ideas more broadly as well.
So if we have anybody either in our audience, either here or remotely, who's writing a dissertation, looking for a dissertation topic, this would be the kind of thing you'd suggest their way. So do some experiments with consumers and see what their revealed preferences are.
Yes, absolutely. That would be very helpful. And so I used to head up, as I mentioned, the policy office, and part of what we did was write advocacy comments to other federal agencies on topics, as well as reports. But often we would draw very heavily upon the academic research that was out there in both law and economics to support what we were saying.
Question up front.
Commissioner, maybe you'd like to elaborate a little bit on the qualitative, quantitative research that was done by the Bureau of Economics on the mortgage disclosures?
Yes, so this was one of the most kind of instructive things that I learned about the effects of regulation. So a number of years ago, HUD was considering doing a disclosure of, it's called the yield spread premium. It's kind of a function of how mortgages, if you get through a broker versus a direct lender, how that person gets paid. And so HUD wanted to disclose this, thinking it would be good for consumers. And the FTC filed a comment that said, you should take a step back and you should test whether it really will make consumers better off. Will they understand that? Not only could it lead to consumer confusion, but secondly, if it seemed to be favoring one side of the market rather than the other, the brokered loans versus the direct loans, it could have a competitive effect. HUD wasn't that interested in what we had to say. Okay, they saw our comment and said, "D, thanks." But then our Bureau of Economics did a study where they actually tested the proposed HUD disclosure and found out that it confused consumers into choosing a more expensive mortgage like a substantial amount of the time, maybe as much as 25% or 30% of the time. So that was a situation in which giving consumers more information, but in a way that wasn't clear to them and wasn't relevant to the decision that they were trying to make, could actually hurt consumers. So then we did studies about what is a better way to have these forms for consumers to disclose this information. And our economists have continued to play an important role in giving this kinds of advice to some of the federal financial agencies. about, look, we understand you have a good goal, you want to give consumers more information, but it has to be in a way that is tested. Are you really achieving what you want to achieve, and is in a context that is explainable and understandable to consumers. Eventually, the HUD rule got pulled, by the way, on the yield spread premium, not just because of our study, but that was at least one of the reasons.
Always glad to hear about the constructive role of economists in the government. Question here?
It's not totally related, but I wonder if you might have an opinion. So on the legislation that's maybe going through the House on cybersecurity and the information sharing that's proposed as part of that, do you envisage the FTC having a role in the future if that expands more broadly away from the core infrastructure into more broad industry, how consumer information might be protected?
So certainly the FTC could, I think, help play a role in explaining, what are some of the types of information consumers consider private, what are some of the steps that we found are necessary to help protect them in private companies. I wouldn't comment about government collection of information or government securing networks, that kind of thing. But for example, one of the things we found in our data security cases is sometimes it's really the weakest link somewhere where the data is getting out. So we've had examples of very basic, you think high tech. Some of our cases have involved companies just taking paper medical records, prescription, data about prescriptions, people's applications for mortgages, and just putting them in the dump, right? Not even shred it. So, or sometimes just your password for your whole system is password, things like that. So I think maybe some practical advice on some of, that kind of stuff, maybe the FTC could be a useful source.
And with that, let's give a round of applause to Commissioner Olhausen. Thank you very much.
Thank you so much, everyone.
This concludes this session of the Center for the Economics of the Internet. Our next session will be on November 28th. Thank you very much.